king refuses to stand. He keeps his hat on. When his cane breaks apart in his own hand in a room he has entered as sovereign, not one person moves to help him pick up the pieces. That is not a detail from a play. It is the trial record of Charles I, King of England, tried by his own subjects in Westminster Hall in January of 1649, and it is not the trial you have been told about. This is the Black Archive, documented crimes and cases from 1100 to 1950, built from the record, not the legend. This case, Charles I, the king who refused the court. To understand why a king came to be seated, hatted and silent before a court of his own subjects, you have to go back further than the war. You have to go back to what Charles believed he was. Charles inherited the throne in 1625, believing, as his father James had taught him, in the divine right of kings. That a monarch's authority came directly from God, not from Parliament, not from the consent of the governed, and that to resist a king was to resist the order of heaven itself. It was not an eccentric personal opinion. It was the operating theory of his entire reign, and for the first years it did not much matter, because Parliament's practical powers were narrow, and its meetings were, in the end, optional, called and dismissed at the king's pleasure. By 1629, Charles had stopped calling Parliament altogether. What followed is known to historians as the Personal Rule, 11 years in which England had a king but no sitting parliament, and in which Charles funded his government through means that did not require parliamentary consent. The most notorious of these was ship money, a tax originally levied only on coastal towns to fund the navy in times of threat, which Charles extended to the entire country in peacetime, year after year, without ever asking Parliament's leave. A Buckinghamshire landowner named John Hampden refused to pay it, on principle, and was taken to court. He lost, narrowly, in 1638. But the case had already done its work. It had put a plain question in front of the country. If the king could tax without Parliament and win in his own courts, what exactly was Parliament for? The Personal Rule did not end because Charles changed his mind. It ended because he ran out of money, specifically to fight a war he had provoked in Scotland by trying to impose an English-style prayer book on a Presbyterian kirk that wanted nothing to do with it. To pay for that war, Charles needed a parliament again, whether he liked it or not. He called one in the spring of 1640, dismissed it within weeks when it would not simply vote him money, and was forced by continued military failure to call another that autumn. That second parliament did not go home. It became known as the Long Parliament, and it would sit in one form or another for the best part of 2 decades. By the summer of 1642, Charles raised his standard at Nottingham, and the country divided into armed camps. Royalist against Parliamentarian, Cavalier against Roundhead, the fighting spread across England, Scotland and Ireland for the better part of 4 years. The turning point came at Naseby in June of 1645, where Parliament's new model army, disciplined, well-paid and increasingly shaped by Oliver Cromwell, broke the king's main field army for good. Charles's private correspondence, captured after the battle, was published, and it showed him negotiating simultaneously with Parliament, with the Scots, and with Irish Catholic forces, offering each side different and incompatible promises. Whatever trust remained in his word did not survive the reading of his own letters. Defeated in the field, Charles surrendered not to Parliament, but to a Scottish army, hoping to play his old enemies off against his new ones. It did not work. The Scots handed him over to Parliament's commissioners in early 1647, and for the next 2 years Charles was moved from house to house, still a king, still treated with the outward forms of kingship, and still negotiating, always negotiating for terms that would restore his full authority. In November of that year, he escaped custody and fled to the Isle of Wight, where the governor of Carisbrooke Castle, uncertain what else to do with a fugitive king, simply kept him there in a comfortable and increasingly permanent captivity. It was from Carisbrooke that Charles made the move that finally exhausted Parliament's patience for good. In secret, he signed an agreement with the Scots, promising to establish Presbyterianism in England for 3 years in exchange for a Scottish army to restore him by force. The result was the Second Civil War of 1648, shorter and smaller than the first, and put down again by Cromwell and the new model army. To the soldiers who had bled to win the first war, the second one was proof of something specific. that Charles could not be trusted to keep any peace he signed, that he would go on turning defeat into a fresh invitation to fight for as long as he remained in a position to do it. That judgment produced the final decisive act before the trial itself. In December of 1648, soldiers under Colonel Thomas Pride surrounded the House of Commons and physically turned away more than 100 members known to favour a negotiated settlement with the king, admitting only those willing to proceed against him. It is remembered as Pride's purge, and what it left behind, a shrunken assembly of some 200 members willing to try a reigning king, was not a full and legitimate parliament by any standard, before or since. It was a parliament built for one specific purpose. Contemporaries called what remained the rump. It is the rump parliament that created the High Court of Justice. It is the High Court of Justice assembled by a purged legislature after 2 wars and a broken word that brought Charles to Westminster Hall in January of 1649. January 1649, Westminster Hall. A king is brought before a court that has never before tried a reigning monarch, on a charge his own laws do not recognise. He is accused of high treason against the people of England. He does not answer the charge. He does not need to. His silence is the argument. 68 members of the court are present that day. There is no throne. There is a chair, plain, at the bar where the accused ordinarily stands. Charles does not stand. He does not remove his hat. In the language of the room, both are refusals. To sit is to decline the posture of a defendant. To keep the hat on is to decline the authority of the court to command him to take it off. He speaks once directly to the President of the Court, John Bradshaw. I would be satisfied by what power I am called hither. Now I would understand by what authority, I mean lawful, I am brought hither. It is the only question that matters to Ahim, and it is the one the court cannot fully answer because no court has ever tried an English king before. Later tellings would flatten this moment into a simple picture, a king on trial standing accused as any man might stand. That is not what the record shows. He remained seated, the hat stayed on. The refusal was not passive, it was the defence. The charge against him, read aloud by the court's solicitor, a lawyer named John Cook, did not use careful or diplomatic language. It named Charles Stuart a tyrant, traitor, murderer and public enemy to the good people of this nation. Cook had drafted it in the belief that this was not simply a political reckoning, but a legal one, that a head of state who made war on his own people had committed a crime with a name, and that the crime could and should be tried like any other. It was, in 1349, a genuinely novel legal argument. No court in England had ever framed a king's conduct of his own government as an indictable offence. Charles was brought before the court not once but across several sessions that January, and on each occasion the pattern repeated. The clerk called upon him to answer the charge. Charles declined and used the moment instead to press his own question, the only one he considered worth asking, about the court's authority to try him at all. By the 3rd session the court had heard enough repetition. Under the criminal procedure of the day, a prisoner who stood mute in the face of a charge refusing either to admit or deny it could in principle be treated as if he had confessed by default. The court did not go quite that far in name, but it moved to hear witness testimony regardless, taking statements on the king's conduct during the wars as though the plea had already been settled against him. Bradshaw's answer to the king is a claim about the nature of kingship itself, and it is worth hearing in full because it is the hinge on which the whole case turns. There is a contract and a bargain made between the king and his people, he tells Charles. Sir, if this bond be once broken, farewell sovereignty. This is not a threat. It is a legal theory that a king's authority is not unconditional, that it is a reciprocal obligation, and that a king who breaks his side of the bargain forfeits his claim to the other. Charles never accepts the premise. He is convicted anyway on the 27th of January, and 3 days later the death warrant is drawn. It survives, and it is worth reading exactly as written. Whereas Charles Stuart, King of England, is and standeth convicted, attainted, and condemned of high treason. 135 commissioners were named to the court. Only 68 ever sat through the trial. 67 stood to affirm the sentence when it was read. 59 names appear on the warrant itself. 2 of them added after the sentence had already been passed. Those numbers are not a footnote, they are the story. A court of 135, on paper, that in practice ran on half that number, that could only produce 59 signatures for the single most consequential judicial act in the nation's history, and that kept adding names after the verdict was already settled. Forensic examination of the warrant's parchment, conducted long afterward, confirms what the numbers already suggest. The document shows a physical insertion over an erasure in the date, and the execution first set for the 27th was pushed back while more signatures were gathered. The warrant was not signed in a single sitting by a unified court. It was assembled over days, one hand at a time, expanded to look more settled than it was. Some of those 59 hands would later claim they had never truly wanted to be there. Richard Ingoldsby, one of the signatories, stood trial himself after the restoration of the monarchy in 1660, charged as a regicide, and offered a defence that has become one of the most repeated stories attached to this case. That Oliver Cromwell had physically seized his hand and forced the pen across the page, that the signature was not his own free act. It is a vivid image, and it is worth being honest about what it is. It is a claim made 11 years later by a man on trial for his life, with every reason in the world to distance himself from what his own name in his own hand said he had done. It may contain some truth. It cannot be taken as settled fact simply because it survives in the record, and the case log for this investigation treats it exactly that way. Sharpened to what it actually is, a specific, dated, self-interested claim, not proof of coercion. On the 30th of January, Charles was executed on a scaffold built outside the banqueting house at Whitehall. He met it, by every converging account, without the fear his enemies had perhaps hoped for, and without the total submission his defenders would later claim. He spoke briefly to those nearest him. He forgave, in his own words, the man who was to strike the blow, though he did not forgive, and said so those he held responsible for bringing him to that place. The morning itself began with a small, deliberate act of composure. It was a bitterly cold morning at the end of January, and Charles, dressing before dawn, asked his groom of the chamber for a second shirt. His reasoning was recorded by those present. The season is so sharp as probably may make me shake, which some observers may imagine proceeds from fear. He said he would have no such imputation. Whatever else is contested about this king, that single request tells you something true about how closely he understood he was being watched, and how much the manner of his dying mattered to him as a final argument in the case he had refused to answer in Westminster Hall. The identity of the man who swung the axe has never been settled with certainty. Contemporary suspicion fell on Richard Brandon, the common hangman of London, and it is the name most histories still attach to the block, but Brandon himself reportedly denied it before his own death only months later, and the executioner that day wore a mask and a false beard, as did his assistant, a precaution against the very real possibility of revenge if the monarchy were ever restored. It is one of the stranger facts of the case. The state could assemble a court, a charge, a conviction, and a warrant in the open, in the nation's own historical record, and yet the single hand that carried out the sentence chose, for its own safety, to vanish into anonymity. What the crowd felt in the moment the blow fell is preserved in one of the most quoted eyewitness lines from the whole event. A witness later recalled that there went up such a groan from the thousands then present as he had never heard before, and hoped never to hear again. It is worth treating that line with the same discipline applied to everything else in this case. It comes from a single recollection, set down after the fact, describing a crowd's noise rather than its meaning, and it has been repeated so often since that it has taken on the weight of settled fact. What can be said with more confidence is what happened in the minutes after. Spectators pressed forward to dip handkerchiefs and scraps of cloth in the king's blood, a practice tied to older beliefs in the healing power of a monarch's touch. Within hours of his death, ordinary people were already treating Charles as something closer to a relic than a defeated politician. The martyr was being built before his body had been moved. 9 days after the execution, a book appeared under the king's name, Eikon Basilike, the royal portraiture. It went through 36 editions within a year, an extraordinary print run for the period, and it did more than any single document to turn a convicted traitor into a martyr. Authorship, though, is contested, and has been for most of the time since. After the Restoration, a clergyman named John Gordon claimed he had written it, not Charles at all. The current scholarly position is that it is a composite, Gordon shaping, arranging, and very likely substantially authoring a text built around genuine material from the king. It cannot be read as Charles's unfiltered voice. It has to be read as what it is, a Tier 2 contemporary document, propaganda in the most literal sense, image-making, not testimony. So the record leaves two Charleses standing side by side. One is the man in Westminster Hall, seated, hatted, refusing to answer a court whose authority he denied on a specific and coherent legal argument. The other is the martyr king of the Eikon, suffering, forgiving, majestic in defeat, a figure built in the 9 days after his death by a book whose true author is still not fully settled. Both images have survived. Only one of them was written down while he was still alive to argue his own case. What can be said with confidence? The trial record and the death warrant are Tier 1 primary sources, and what they show is a prosecution that never achieved the unified quorum its own paperwork implies. What cannot be fully settled? How much of the Eikon's voice is the king's, and how much of Ingoldsby's later story is confession rather than alibi? The Black Archive marks both as open. The record does not close every question, it only tells you precisely which ones remain. The men who signed the death warrant did not get to consider the matter closed. When the monarchy was restored in 1660 under Charles's own son, one of the new king's first acts was to hunt down everyone still living who had put a hand to that document or otherwise driven the prosecution forward. Parliament granted a general pardon to almost everyone associated with the wars. But the regicides, the men directly tied to the trial and execution, were carved out by name and excluded from it. 10 of them were executed in October of 1660 at Charing Cross and at Tyburn by the traditional and brutal sentence for treason, hanging, drawing, and quartering. Thomas Harrison, one of the most committed of the regicides, went to his death still defending the trial as an act of righteous judgment rather than murder. John Cook, the solicitor who had drafted the original charge naming Charles a tyrant and a public enemy, was executed alongside him. The lawyer who had built the legal argument paying in the end exactly the same price the king had. Some of the regicides could not be punished the ordinary way because they were already dead. Oliver Cromwell had died of natural causes in 1658, 2 years before the Restoration, and had been given a state funeral and burial in Westminster Abbey, the same building that stands beside the hall where Charles was tried. In January of 1661, on the 12th anniversary of the king's sentencing, the new government had Cromwell's body dug up, along with those of 2 other prominent figures from the trial and the wars, and subjected it to a posthumous execution. Hanged in chains at Tyburn for a full day, then beheaded, the head placed on a spike above Westminster Hall itself, where it remained for years. The symmetry was deliberate. The regime that had tried a king in that hall now displayed the head of its most famous defender above its own roof. This is where Richard Ingoldsby's claim belongs in the fuller picture. Standing trial as a regicide himself in 1660, with the fate of Harrison and Cook as a visible warning of what conviction meant, Ingoldsby argued that Cromwell had physically forced his hand onto the warrant and guided the signature against his will. Whatever the truth of the moment 11 years earlier, the claim worked. Ingoldsby was one of the few named signatories to escape execution, pardoned in part on the strength of that story. It is a useful reminder that the survival of a historical account and the truth of a historical account are 2 different questions, and that the men who lived through the Restoration had every incentive in the world to reshape what they had done in 1649 into something they could survive telling in 1660. Beyond the individual reckonings, the trial left a longer shadow over the English constitution than any single execution could. No monarch before or since has ever again been put on criminal trial. The government of the day understood exactly what the Eikon was doing and moved to answer it directly. Parliament commissioned the poet and polemicist John Milton, already known as a defender of the regicide on political grounds, to write a formal rebuttal. The result, published later in 1649, was Iconoclastes, the Image Breaker, a book-length attack that went through the Eikon almost line by line, arguing that its pieties were performance, that a king who had provoked 2 civil wars had no standing to present himself as a suffering innocent, and that the public's hunger for the martyr image said more about the public than about the king. Milton's book was a commercial and cultural failure by comparison. The Eikon kept selling. The Image Breaker could not outpublish the image. It is one of the clearest demonstrations available from this period of a fact that will sound familiar from any later century. A well-timed, emotionally satisfying story reliably outperforms a well-argued rebuttal, regardless of which one the evidence favours. By Parliament. The lesson the political class drew from the whole episode was not that kings could be lawfully judged, but that trying to do so tore the country apart and then required decades of retribution to settle. When the monarchy was challenged again in 1688, the method was different by design. No trial, no execution, simply the negotiated departure of one king and the invitation of another, followed by a Bill of Rights in 1689 that limited royal power through statute rather than through the executioner's block. Constitutional monarchy in England was built in large part as a way of never needing Westminster Hall again. That is the final open question this case leaves behind, and it is not really about the 17th century at all. A court assembled by a purged parliament, prosecuting a king for putting himself above the law, using an argument about accountability that was, on its own terms, genuinely sound, and doing it through a process that was itself irregular, incomplete, and manufactured to look more unified than it was. Both things are true at once. The Black Archive does not resolve that tension for you. It only insists that you look at both halves of it together rather than the one half that makes for a cleaner story. Every fact in this case that touches the trial record, the death warrant and its forensic examination, was cross-checked against direct primary source retrieval before being scripted, in keeping with the standing rule for this archive. No claim treated as established unless tied to a cited Tier 1 source, contemporary material used only to explain how events were framed at the time, and later material flagged plainly as later memory rather than allowed to overwrite the record. The trial transcript and the death warrant carry that Tier 1 status here. The Eikon Basilike does not, and has been treated throughout as what it is, a contested and commercially motivated document rather than the king's own unmediated voice. 2 things in this case remain genuinely open, and this archive would rather name them than quietly smooth them over. The first is Ingoldsby's account of a forced signature, which cannot be verified independently of his own later self-interested testimony, and is presented here exactly as that, a claim, not a fact. The second is the true extent of John Gurdon's hand in the Eikon Basilike, which modern scholarship treats as a composite text rather than a settled question of single authorship. Where the record allows confidence, this account states it plainly. Where it does not, the uncertainty is the finding. News of the execution reached the continent within days and landed as a genuine shock to nearly every court in Europe, regardless of religion or politics. This was not simply the death of a monarch, of which Europe had seen plenty. It was a reigning king, tried in open court by his own subjects on a charge of treason against them, and then publicly executed on a scaffold in the middle of his own capital. No precedent in living memory matched it. Even governments with no love for Charles or for the Stuart monarchy reacted with alarm rather than satisfaction, because the underlying argument that a king answered to his people and could be tried and punished like any other subject if he broke that trust was not an argument any hereditary monarchy in Europe wanted tested closer to home. Charles's own son and namesake, watching from exile, would spend the next decade insisting on the sanctity of the crown with a rigidity his father might have envied, precisely because he had watched, at close range, what happened when that sanctity failed to hold. One small moment from the trial itself is worth closing on, because it says more about the room than any speech did. At one point during the proceedings, Charles reached out with his silver-headed cane to tap the court solicitor on the shoulder, signalling him to stop speaking. The silver head came loose, fell from the cane, and rolled across the floor of Westminster Hall. In an ordinary royal setting, a dozen hands would have moved to retrieve it before it finished rolling. Here, in a hall he had entered as king and would leave as a prisoner, nobody moved. Charles had to bend down and pick it up himself. Eyewitnesses who recorded the moment treated it as strange enough to write down, and it has survived for that reason, not because anyone planned it as a symbol, but because everyone in the room understood in that small silence exactly what it meant that no one reached for it but him. Accounts converge, though none can be called a verbatim transcript, on the substance of what Charles said in his final minutes on the scaffold. He spoke of the crown he was leaving and the one he believed he was going to, telling those close enough to hear that he went, in effect, from a corruptible crown to an incorruptible one, where no disturbance could follow him. It is a line that has been quoted in nearly every account written since, and it is worth noting exactly what kind of evidence it rests on. Near contemporary witness memory, not a signed statement, not a court record, recorded by men who had every reason to want the king's last words to sound dignified and composed. That does not make it false. It makes it the same category of evidence as the groan of the crowd. Probably close to what was said, shaped in the retelling, and impossible now to separate cleanly from the legend that formed around it within hours of his death. One more figure belongs in this account before it closes. The crowd itself, thousands of ordinary Londoners who turned out on a freezing January morning to watch a king die, many of whom had lived their entire lives under his rule and had no memory of any other head of state. Soldiers lined the route and surrounded the scaffold in unusually heavy numbers, a precaution against exactly the kind of last-minute rescue or riot that a nervous new government could not afford, which tells you that even the men who had engineered this outcome were not entirely certain how the public would react in the moment. What they got instead was silence, then the groan, then within hours the first rush to the scaffold for relics. A regime that had just executed a king for placing himself above the law spent its very first afternoon in power watching that same king's ordinary subjects treat his blood as sacred. Within 11 years, the ground had shifted back completely. If there is a single through line across every act of this case, it is this. Power that claims to answer to no one eventually meets a room that disagrees, and the room is rarely tidy about how it makes its case. Westminster Hall in January of 1649 was not a clean court delivering clean justice. It was a purged parliament, a manufactured quorum, and a genuinely serious legal argument, occupying the same afternoon, refusing to cancel each other out. That is the account, cane and all. A king who lost the argument over sovereignty in a purged parliament, and still, for a while, won the argument over sympathy in print. 2 Charleses built from the same 9 days. If this case was worth your time, a follow or a rating helps the next one reach the record. Next on the Black Archive, Mary Ann Cotton, accused of poisoning her way through 3 husbands, a lover, and as many as 11 children in industrial northeast England, convicted almost entirely on circumstantial evidence. The record on her is far messier than the legend admits. This has been the Black Archive. Documented crimes and cases from 1100 to 1950, built from the record, not the legend. Thanks for listening. Until next time, goodbye.